that were illegal did not despair. They at once set up the baseless claim that the decision of 1896 disturbed the business interests of the country, and let it be known that they would never be content until the rule was established that would permit interstate commerce to be subjected to reasonable restraints." Other great causes involving the same issue were tried. The question was repeatedly re-argued, but the Supreme Court tenaciously adhered to its general principle that, under the Sherman Act, all restraints of trade or monopolies were unlawful, and therefore the court had but two matters before it: first, to define a restraint of trade or a monopoly; second, to determine whether the particular combination complained of fell within that definition. No discretion was permitted. Judicial duty ended there. The court being found to be inflexible, recourse was had to Congress, and a bill in the form of an amendment to the Sherman Act was brought into the Senate, authorizing, in substance, those who felt unsafe under the law to apply to certain government officials to be permitted to produce evidence of the reasonable methods they employed, and, if the evidence were satisfactory, to receive what was tantamount to an indulgence. The subject thus reopened, the Senate Committee on the Judiciary went into the whole question of monopoly anew, and in 1909 Senator Nelson presented an exhaustive report against the proposed relaxation. Thereupon the Senate indefinitely postponed further consideration of the amendment. The chief reasons given by Senator Nelson were summed up in a single sentence. "The defense of reasonable restraint would be made in every case, and there would be as many different rules of reasonableness as cases, courts, and juries. To amend the Antitrust Act, as suggested by this bill, would be to entirely emasculate it, and for all practical purposes render it nugatory as a remedial statute. The Act, as it exists, is clear, comprehensive, certain, and highly remedial. It practically covers the field of federal jurisdiction, and is in every respect a model law. To destroy or undermine it at the present juncture would be a calamity. In view of the foregoing, your committee recommend the indefinite postponement of the bill." And so the Senate did indefinitely postpone the bill. Matters stood thus when the government brought process to dissolve the Standard Oil Company as an unlawful combination. The cause was decided on May 15, 1911, the Chief Justice speaking for the majority of the bench, in one of the most suggestive opinions which I have ever read. To me this opinion, like Taney's opinion in the Charles River Bridge case, indicates that the tension had reached the breaking point, the court yielding in all directions at once, while the dominant preoccupation of the presiding judge seemed to be to plant his tribunal in such a position that it could so yield without stultifying itself hopelessly before the legal profession and the public. In striving to reach this position, however, I comprehend that the Chief Justice unreservedly crossed the chasm on whose brink American jurists had been shuddering for 90 years. The task the Chief Justice assumed was difficult almost beyond precedent. He proposed to surrender to the vested interests the principle of reasonableness which they demanded, and which the tribunal he represented, together with Congress, had refused to surrender for 15 years. To pacify the public, which would certainly resent this surrender, he was prepared to punish two hated corporations, while he strove to preserve, so far as he could, the respect of the legal profession and of the public for the court over which he presided, by maintaining a semblance of consistency. To accomplish these contradictory results, the Chief Justice began, rather after the manner of Marshall in Marbury v. Madison, by an extrajudicial disquisition. The object of this disquisition was to justify his admission of the evidence of reasonableness as a defense, although it was not needful to decide that such evidence must be admitted in order to dispose of that particular cause. For the Chief Justice very readily agreed that the Standard Oil Company was, in fact, an unreasonable restraint of trade and must be dissolved, no matter whether it were allowed to prove its reasonable methods or not. Accordingly, he might have contented himself with stating that, admitting for the sake of argument, but without approving, all the defendant advanced, he should sustain the government, but to have so disposed of the case would not have suited his purpose. What the Chief Justice had it at heart to do was to surrender a fundamental principle, and yet to appear to make no surrender at all. Hence he prepared his preliminary and extrajudicial essay on the human reason, of whose precise meaning, I must admit, I still, after many perusals, have grave doubts. I sometimes suspect that the Chief Justice did not wish to be too explicit. So far as I comprehend the Chief Justice, his chain of reasoning amounted to something like this. It was true, he observed, that for 15 years the Supreme Court had rejected the evidence of reasonableness which he admitted, and had insisted upon a general principle which he might be supposed to renounce. But this apparent discrepancy involved no contradiction. It was only a progression in thought. For, he continued, the judges who, on various previous occasions, sustained that general principle must have reached their conclusions by the light of reason. Today we reach a contrary conclusion, but we also do so by the light of reason. Therefore, as all these decisions are guided by the light of reason, they fundamentally coincide, however much superficially they may seem to differ. I have never supposed that this argument carried complete conviction either to the legal profession, to the public, or to Congress. Certainly it did not convince Mr. Justice Harlan, who failed to fathom it, and bluntly expressed his astonishment in a dissenting opinion in another case from which I regret to say I can only quote a couple of paragraphs, although the whole deserves attentive perusal. Quote, "If I do not misapprehend the opinion just delivered, the court insists that what was said in the opinion in the Standard Oil case was in accordance with our previous decisions in the Trans Missouri and Joint Traffic cases, if we resort to reason. This statement surprises me quite as much as would a statement that black was white or white was black. But now the court, in accordance with what it denominates the rule of reason, in effect inserts in the act the word undue, which means the same as unreasonable, and thereby makes Congress say what it did not say. And what, since the passage of the act, it has explicitly refused to say. In short, the court now, by judicial legislation, in effect, amends an act of Congress relating to a subject over which that department of the government has exclusive cognizance." End quote. The phenomenon which amazed Mr. Justice Harlan is, I conceive, perfectly comprehensible, if we reflect a little on the conflict of forces involved, and on the path of least resistance open to an American judge seeking to find for this conflict a resultant. The regulation or the domination of monopoly was an issue going to the foundation of society, and popular and financial energy had come into violent impact in regard to the control of prices. Popular energy found vent through Congress, while the financiers, as financiers always have and always will, took shelter behind the courts. Congress in 1890 passed a statute to constrain monopolies, against which financiers protested as being a species of confiscation, and which the Chief Justice himself thought harsh. To this statute the Supreme Court gave a harsh construction, as the Chief Justice had more than once pointed out when he was still an associate upon the bench. From a series of these decisions an appeal had been made to Congress, and the Senate, in the report from which I have quoted, had sustained the construction given to the statute by the majority of his brethren with whom the Chief Justice differed. Since the last of these decisions, however, the complexion of the bench had been considerably changed by new appointments, much as it had been after Hepburn v. Griswold, and an opportunity seemed to be presented to conciliate everyone. In any other country than the United States, a Chief Justice so situated would doubtless have affirmed the old precedents, permitting himself at most to point out the mischief which he thought they worked. Not so a lawyer nurtured under the American constitutional system, which breeds in the judge the conviction that he is superior to the legislator.